Thank you very much. The next portion of the program has been variously entitled. It's in the program as Computational Law and Contracts, and here as Contract Analysis. And indeed, we're going to be spending the next hour and a bit in a conversation around contracts as the focus, but not as the limiting focus. Rather, I think as a departure point for talking about some of the things that law can do more generally and where some of this is going. I'm Oliver Goodenough. I'm a faculty fellow at the Berkman Center at Harvard and also a professor of law at Vermont Law School. And what we're interested in here, I think really it uses the last panel as a departure point really to go forward. Because you've heard how technology may be changing the consumer side of the law. I think we're really here looking at how it changes the nuts and bolts of the law, how it changes what goes on inside the mechanisms of law. And in that way, I think we're going to hear about how law can look quite different. We're going to hear about automating current practice, and that's terrific. But we're also going to hear about the potential for completely disrupting and perhaps even replacing current practice in terms of what the law does and how it works. We're lucky in a distinguished panel. We have 3 folks from the private sector, 1 from the public sector, and me, 1 professor, wherever I fall in all of that. I'll give a very brief introduction just to our folks. There's a long introduction in your program. Going alphabetically, we have A.J. Agrawal, who is the co-founder and CEO of Sirion Labs. He, like actually everybody on this panel, is law trained, and at least in one way or another, at some point in their career, I believe, law qualified. But A.J. is also a background as a founder of United Lex Corporation, which he sold to some advantage some years ago, and is now has a new project really aimed at legal contract automation. Also in the private sector in a similar vein is Kingsley Martin. Kingsley is the CEO of a company that has been called Kayak, but is now KM Knowledge Management Standards, and is also one of the leaders in questions of contract automation. Our third private sector participant is Jamie Wadetsky. He is the founder and one of the principals of a company called Exari, Boston-based, and also a significant player in the contract automation field. And finally, I want to introduce Ross Miller. We are very lucky to have him here with us. He is the Secretary of State of Nevada. And I think we've gotten him partly because he is a Stanford graduate and was willing to come back and visit the old turf. But he has been active. He's a very forward-looking government official who has been using automation to help support business formation and business operations in Nevada in some very interesting ways that I hope we will hear about. So, last thing to say is we're going to be slightly differently organized. I'm going to give each of these folks a bit of a chance to talk, but they're going to talk around themes, because as we look at this, I've talked about what are some of the themes that we see as we automate contracts. The themes I've been seeking to develop are, first of all, standardization. We can look at standardization. Secondly, analysis. Thirdly, contract formation. Fourthly, operationalization of contracts. And fifth, last but not least, making them computable, looking into computation as a goal for contracts. One last little caveat from my part. I am a consultant to the U.S. Treasury Department, and none of the opinions that I will express are those of the Treasury Department. They are all my own and should not be imputed to any governmental entity. Thank you very much. I'm going to start off with Jamie.
And I have a very weak voice at the moment, so I'm going to eat the microphone in the hope that you can hear me. So my company, Exari, focuses on automating contracts and is particularly good at automating the creation of contracts. And we're used by just, amongst others, a half dozen of the world's biggest investment banks and banks to do things like ISDA-master agreements and derivatives contracts, and then a whole slew of other things. So I've been, for the past 13 years, doing contract automation in the field. Picking up on the previous theme, or the previous session, I kind of was pleased that it got to what I see as the only real issue here, which is that there are regulatory barriers. There are no other issues. I mean, there are regulatory barriers. The legal profession is expert at building regulatory barriers. And it's a bit like, deregulating is a bit like turning up at a gunfight with the NRA with a pointed stick. I mean, you've got a bit of an uphill battle ahead of you. I'm also going to disagree. I think it was one of the LegalZoom people who said it's not about technology. I think it actually is about technology. I mean, essentially technology is the key enabler of the change. And let's face it, the machines are coming. This is not something the legal profession really wants to hear, but it's true. And if anyone tells you there's just going to be an ever-ending growth in the number of lawyers in the world, I think that's also kind of not true. The machines, if machines can do something better than people can do it, machines will do it. They're cheaper, they're faster, they're better, right? So the question really is, what can machines do better than people, and how quickly can the regulatory barriers be removed from that? Now, if you look at contracts specifically, there's kind of a bunch of, that deconstruct what goes on in people who do work around contracts. The first things most businesses want is to make sure that they've aggregated all their contracts in one place and they know what they're signed up for. So, that task of aggregating contracts is something a machine can generally do better than people. The second thing is to kind of capture important data out of it so that you can run reports, you can do analytics, this sort of whole analysis thing. This is something machines can definitely help with, but also needs a human element. So I think on the analysis side, you have a combination of machines and people sort of living forward into the future. Then with contracts, something law firms really care nothing about, but businesses care something about, is what I would call operationalization, as in taking a contract and putting it into operation and having the people execute against it. This again is something machines can generally do better. If the obligations in the contract have been kind of captured in some way, the machine can feed it into a whole bunch of systems so that people who need to do things and need to be reminded about things do them and are reminded about them. And just to take one anecdote, in banks, when you do these master agreements for the derivatives industry, it has all sorts of stuff about, collateral management and what sorts of collateral are eligible collateral and what the valuation percentages are. And there's all this kind of stuff which the lawyers draft, but the bankers then need in their systems to execute against. So you've got to make sure the data flows quickly and cleanly. The next thing that happens in the world of contracts is that people create them. They draft them and then they negotiate them. On the drafting side, again, machines can do, in many, many cases, a better job. As long as the task is a predictable one, the machine can automate that process and help any old human who doesn't need to be a lawyer to produce a good first draft and sometimes a final. Negotiation, on the other hand, is something that people will do better, I think, nearly all of the time. So lawyers, I guess there's this saying about where big law goes, they all retreat up market. Unfortunately, there's not enough room up market for them all to retreat. But if you're a good negotiator, you'll have a job. And then the last thing I would talk about would be the sort of the dispute, conflict, litigation kind of end of things. And again, that's where usually the stakes are higher and therefore people are willing to pay for the first-class service and have people involved. And my only other comment, just to kick things off, would be that, going forward, to repeat my earlier comment, the key thing is to remove the disabler, so deregulate both this whole business about, the practice of law, and secondly, the access to capital and the sort of legal structures. And by the way, Australia did this first, and then, I'm Australian just in case you couldn't tell. Australia did this first, then the UK has done it, but the US is sort of nowhere. So this is the problem. And then the second thing I'd sort of flag is this idea of standards, that if there are better standards in contracts, and I think Kingsley will talk a lot more about this, but if there are better standards, then you have much better ways to automate things, so both from a creation and from an analytics point of view. And with that, I will
Well, before I turn it over, we're going to go to Kingsley next, but I wanted just to push you a little bit on the question of negotiation. You say that humans are better at that than machines, and humans are better at negotiation as we are aware of negotiation. Could you conceive of a world in which the thing that we use negotiation for could be, in fact, automated?
Yes, but it's not coming soon. So I guess there's definitely going to be a day when, and this is where it hangs on standards, because there's going to be a day when, software agents could be told to go and bang heads against each other and, come up with an agreement about something. So if you can program a software agent with the correct parameters, and those two agents can talk the same language, right, which is where the standards are critical, then you could have machine negotiation. But I think that's a much further step. I mean, that's probably more like 5 years.
You mean much further, i.e. 5 years, you say?
At least 5 years, yeah.
Okay. Our next, we're going to turn to Kingsley, who has prepared a bit of a presentation for us, so he's going to do from here.
Thank you, Oliver. Good morning. I'm Kingsley Martin. I'm the founder of KM Standards, formerly known as Kayak. Now, I am standing up here to do some slides because it's a lot easier to show contract analysis with some images as opposed to finger puppets. And I'd like to show you how we actually do it. And I'd like to reiterate what Jamie said, that I'd like to make a case for technology. What we're fundamentally attempting to do is demystify the contract process using the technology. The technology automatically creates contract standards from a source set of documents. Without any pre-training, it learns everything about the contracts from the document itself. From that, we can create standards, and we can benchmark any document to it. But if I have an agenda in coming here today, is we have the technology. We can also use this technology to create contract standards. I think we can do this together. We can do it globally. It is not an intractable problem. If we work with, say, the law schools or other people in this field, we could literally establish global contract standards. So let me show you how. We're taking an inductive process. We start with a pile of documents. When I first started trying to do this inside of law firms, we did it the other way. We did it deductively. We sat down and worked with the attorneys and asked them, how would you configure this document? Today, what we do is essentially start with a set of source documents, whether they come from a private law firm, corporation, ACC, public collection like Edgar. And what we want to know is how they're organized, what clauses do they contain, and what's the standard, the range of standard and alternative language. And the way we do this, we start with simply deconstructing the entire set of documents into their source clauses. So now we've got all of the bases, every single clause from every single document. And what we then do, we built an inductive engine. And what it is a structural classification engine that can take all of those pieces from all of those contracts, and for example here, outline what we find in an employment agreement. Those are all of the clauses that we see. And the key thing that we are detecting, and I think of this as the vertical dimension. And indeed, one of the things we're attempting to do today is create this into something like an iPad app. I think we could even make drafting fun again. Come to an application like this, and you're scrolling in the vertical plane, which is the relevant elements that we expect to see in this contract. And what the statistics do is it tells you how frequently we see each of the clauses in each of these components of the document. So we know certain clauses appear really commonly. They're in essence required. We know that certain clauses appear in some, but not all of them. I'm doing a similar kind of analysis with some banks right now who are trying to pull together and make their employment contracts consistent across multiple geographies. This is a good example. You'll see a base salary in every single one. We see an overtime clause in a smaller percent, and we can determine, and we can start to think about what are the characteristics that you essentially use one of those clauses. Obviously, it's an hourly based person. It's a non-exempt position in that particular case. In addition, we can also take a look horizontally at the consistency of the clause language across that set, so that we can find essentially how those clause language stack up. We're going to find in certain parts of the contract the language tends to be really, really similar and really, really consistently similar across the set. It is, in fact, a standard. We find instances where there's a huge amount of variation. in the clauses, which should be indicative of the fact there are some alternative ways to draft this. But again, we can detect this using the power of technology. So in this particular case, and this is just showing you actually screenshots from the application, that as you go down vertically through the document, you can then go to a clause like the base salary and start to scroll in the horizontal dimension and determine the one that most fits your circumstance and literally pin it into your document. So that's the other dimension, is that in that horizontal dimension, we're looking at consistency of the language in order to detect which clauses in this set are standard and which are highly variant, which will presumably have certain concepts. Well, hopefully I'll have a few moments to show you how we can even go down into the depths of that variance. So what it really sets up in this contract is two dimensions: a vertical dimension of frequency or commonality, and a horizontal dimension of consistency, which sets up a very powerful review matrix. We find certain clauses in that upper right dimension that are really common and consistent. We can call them standard, we may even call them boilerplate. Hopefully we can establish those standards and agree upon them. We find clauses that are really consistent, but highly variant. They can be for one of two reasons: because they're highly negotiated, or they're different circumstances that the contract is addressing. I'm going to write the employment clause differently for a CEO than I am for a programmer. But they're also different, we find, and we can detect this with great accuracy, because there's personal preference or historical circumstances driving it. That's what we're trying to really focus on. So when we're reviewing a set of contracts, we often look at that upper left dimension. There are clauses that are uncommon, but when we see them, they're really consistent. They're quite interesting. They turn out to be markers of certain transaction types. I see this, for example, an equity provision in the employment agreement. When I see it, we know that it's pretty consistent. Or actually, the best example is an offer clause in a merger agreement. We don't see it in very many, but when we do, we know that this merger is set up as a tender offer. And when we see it in those documents, they're highly consistent. So what we end up with at this stage of the game is that we can start to reverse engineer the legal logic out of these documents. We know the questions. It's almost the opposite of the Hitchhiker's Guide to the Galaxy. We know what's required, and we know what's optional. We know what's standard, and we know what's variant. And so now we can actually reverse engineer and induce a term sheet from the set of documents. So we're doing this on a consistent basis now. So what we might end up from this analysis is a fill in the blanks that hopefully we can feed to Jamie's company, that he can automate the production process. That's the stage I think we're at right now. We know the questions, but we don't know the answers yet. And Noel, if you indulge me for just a few more seconds, maybe I can just disclose how we might go to the next stages. The next stage is optimization of the contract, and again, using the technology. We want to know, for example, this is an organization clause from a merger agreement, and I'm hoping that within this year, just like in the EDD market, we can have a head-to-head with the lawyers in a drafting contest, and with a blind test, have lawyers in the room rate who did the better job. I think we can get there. I think we can find the best way. Not only can we find the elements of this particular clause, but we can even find the best way to draft each of those elements. If you actually looked at in the organization clause from an acquisition agreement like a merger, what you'll find is there are sub-elements to that clause. And if you just analyze, for example, this particular one, I was using around 60 merger agreements to build a set. If you were just to look at that organization clause and read them all, you're looking at reading 25 pages. We've now written software that can organize, just as we can analyze and summarize all of the agreements into that common outline, so now we can analyze all of the clause elements. These are the things that we expect to see, and we just color code them. Okay. And we can now write algorithms designed to find the best way to draft something, to make it clear and concise. So the last piece, I will leave some of the slides or later or for later discussion. The last piece of it is that we can now start to extract the key data out of it. The names, the dates, the amounts, the triggers. And it should be those things that really configure the document. And if we can create a colossal database of all of these provisions, the non-compete periods, the salaries, the grounds for termination, we should be able now to go back and ask, why was that contract drafted in this way? And we can create a measure. And the software can, in fact, take any agreement and benchmark it to the standard, tell you how your document stacks up, what's consistent, what's divergent, and even what's missing. But I'll leave it there, because I'm sure we can dig into this later.
I'm going to ask one question using my prerogative, which is, this is terrific, but does it codify existing practice? In a sense, you're measuring against the best of the existing practice. Does it have the opportunity to go beyond, or will it actually converge us back onto a set of things which are the existing norms rather than push us into new territory?
Well, I think it's fundamentally what it does. I mean, I kind of think in some ways it's like the codification of common law, which was simply habit and practice. And what we're doing is that we're data mining the existing documents to establish, and we can do this even amongst law firms, we can establish and define de facto consensus, or sometimes, unfortunately, lack thereof. But yes, I mean, it really is defining what is.
Okay. Thank you.
Thank you.
AJ. We're moving through some of the list here. We've seen standardization a bit. Here we've got analysis going forward. With AJ, I think we're going to move into operationalization. There we go. That's the hard word of the day.
Sure.
You want to come up as well?
I think I'm happy to speak from here.
Okay.
If somebody could just...
I'll do it.
So I guess my role in this is to speak of the operationalization. Operationalization. Can everyone hear me now? Yep. Is this better? To speak on operationalization of contracts. Better? Okay. So I'll start with a small story, anecdotally, and then I'll build up to what my focus area is. In 2008, in my previous company, United Lex, we were selling what was a bread and butter product to one of the world's largest IT services companies, CSC. The product was building an electronic contract database for their 429 enterprise customers spread over 3 continents, driving about 2/3 of the company's revenue, $11 billion. And the objective of the contract database was to serve the legal and the contract negotiation community within CSC to help them keep track of the legal essence, if you will, of that contract or of those sets of contracts with their core customers. During the course of the conversations with them, it transpired that the CEO had instructed the incoming GC to solve the problem of contract education. I had never heard this phrase before. So I asked the GC, I said, what do you mean by contract education? And he said, look, at CSC, we have great negotiation teams, so we get great contracts, well-negotiated contracts, and we have great delivery teams, so they do a great job of delivering it. And so, therefore, we have $11 billion in this segment of revenue. The problem is that these two teams don't talk to each other. So the delivery team delivers what they think they're supposed to deliver versus what's written in the contract. And 2 key problems arise from this. A, they miss stuff that they're supposed to do, which drives revenue leakage, penalties, disputes, early terminations. And B, they over-deliver and under-invoice. So they end up performing stuff that they were not supposed to do. And my simple question to him was, in that case, why are you asking me to build you an electronic contract database and capture only legal metadata for these enterprise contracts? Shouldn't I be capturing the business obligations that you owe to your customers? And more importantly, then linking them to the obligation owners inside your operational staff and automating the process of delivery itself. And he said, sure. I mean, if you can do that, that would be the ultimate answer. And so that's where the journey began. We built an enterprise-class platform. had 75 software engineers. It took a long development cycle, millions of dollars invested. CSC loved that solution. It drives their global delivery infrastructure today. We trained over 32,000 people worldwide on how to do that system. The problem with that product, if you can call it that, is that it was a very long sales cycle. And when we tried replicating it at IBM, Capgemini, BT, some of the other largest service companies in the world, we found that it took us almost 20 months to sell one of these deals, even though it gave us very large, chunky $4 or $5 million recurring contracts. So I exited from the previous company back almost 2 years ago now, and took a little bit of a break. Was fortunate enough to get associated with CodeX and rethink some of my premises. And what I realized is that instead of targeting the suppliers of these complex services, I should really have been talking to their customers. Because when a large company like JP Morgan or Unilever outsources their IT environment or their finance and accounting or HR or procurement, it leaves a big vacuum in the company. And the ability, therefore, to monitor the incoming vendor at thousands of different levels and make sure that you're getting what you contracted for is minimal. And therefore, the ability for software or technology to step into this gap is a very pressing requirement. And really the way this problem can be studied from two directions. About 10, 11 years ago, there was a massive disruption in the procurement and quasi-legal space with the formation of two companies, Ariba and Emtoris. And as most of you will probably know, Ariba was acquired by SAP for $11 billion last year. Both of those companies, the disruption that they formulated about a decade ago was that we should have a one-size-fits-all approach to procurement. And broadly speaking, they came up with that discipline that should be followed both in acquiring services and products and also then managing vendors and their risk and the performance and the financial aspects of sourcing thereafter. What they overlooked in designing this one-size-fits-all is the Pareto rule. 4% of suppliers account for more than 80% of the spend. And if you use the same one-size-fits-all approach to manage them, then you will essentially end up under-managing the leakage that accrues from those suppliers. So to compensate for this problem, they then hired armies of people to manually do all the things that the software of Ariba and Emtoris could not do. And it is that gap, if you will, post-signature and pre-dispute. If you think about it like lawyers relate to contracts, your role is in negotiation leading up to signature, and then you have the occasional intervention to interpret a contract, but really the next time you hear about it is when it's in a dispute, right? And you either, it's a contractual dispute and you have a corporate resolution, or it ends up in litigation. But I would argue, and this has been the central learning of my life, all my patents and my intellectual property is concentrated around this one learning, is that the value, somebody talked of value earlier in this context, of a contract lies neither in negotiation nor in dispute. Its central value lies in operationalization. How does that contract actually get performed during its life cycle? I deal in arguably one of the most complex class of contracts in existence today, which is complex outsourcing contracts, which the average contract is about 1,200 pages in length, contains more than 1,800 active obligations to be monitored on monthly intervals. So I agree, not every contract fits that profile. But if you take this as an exemplar and you figure out that when you cross the boundary from thinking narrowly as a lawyer and starting to understand what the broader outcome that contract was supposed to achieve and how it fits into the business as a whole, and bridge the gap between the supplier and the buyer of those services, that's where real value can be generated. If you look at the diagram which is up there, it pictorially represents some of what I've been talking about, is how contracts, what I call bulky data objects, are really comprised of these underlying atomic units, which I call obligations. And obligations, I don't mean obligations the way we are taught in law school. In law school, we are taught that the law of contracts and torts is the law of obligations. I mean a much broader sense of obligations, including business obligations, performance obligations, service level credits, which are not taught as obligations to us in law school. And once you start thinking more broadly in that way, and I think my journey, if I can just kind of sum it up very briefly, is a journey that began very narrowly in the law. I'm a Cambridge-educated black letter lawyer, practiced with Simpson Thacher for the first 2/3 of my career. I never really thought in these terms. But for me today, when I look at the kinds of issues that I'm talking about, the realization was the outcome, the value of what I was doing lay outside the narrowly defined legal parameters that I was following. And for me, technology, I think someone very correctly pointed out in the previous panel, is an enabling agent. It is not the end outcome of this. I don't think technology alone will drive this big change that we're talking about. If you look at the cluster of patents and innovations that we are filing at Sirion Labs, one small one is a parsing algorithm that automatically reads these very, very large contracts and dissects them into their constituent obligations. But that in and of itself is meaningless till you figure out how to reconnect these in some sort of neural network and figure out how causality is, or interdependency is driven between these obligations, how they relate to the obligation owners, the value that they drive, relative value between themselves. It's very hard to operationalize them. So these are some of the issues that I've encountered and attempted to straddle between the two companies that I've worked on.
Thank you very much. I'm finding I'm repeating myself a little bit in my question, which is, so you are maintaining that this technology will enable better lawyering at a certain level, get many of the sort of easy questions out of the way, as it were, and then people can strategize and know. I'm going to push you on that, because at the end of the day, can you imagine a world in which we automated some of those other processes as well, some of the advice giving, and if we have neural networks on this, or is the human still the necessary element in the chain?
I would argue there are three parts to it. One is reforming the process. I think there has been a lot of emphasis in today's discussions on the technology component, but disaggregating legal analysis into its underlying process and then figuring out, whether using Lean Six Sigma or other techniques, whether those processes themselves can be made more efficient is one part. Second is also, and I think this has received little attention in today's discussions, is de-skilling legal processes. Is it really necessary that you need legal professionals to do legal processes? And I would argue to the contrary. And certainly that was my experience. We had, in my previous company, 900 legal professionals, and one of my constant endeavors was how to reduce the number of lawyers in that 900 over time. We got it down to 44% by the end. And the third, I would argue, is automation. People, again, technology and automation get conflated, and that's not really a good conflation either. I would argue that the higher and better use of technology is in value-added analytics. Today, and again, someone I think made a very valuable distinction between data and information, and I would argue there's a paucity of the latter in the way we're approaching it. So information, for just a quick layman description, would seek to answer important questions like what happened, why did it happen, based on what happened, what is likely to happen, and based on what's likely to happen, what should I do about it? And if you can get quantitative answers to that based on the data that you manage, then you're really achieving meaning. You're bringing the legal universe in line with finance and accounting, with HR, with procurement. These are already given units of meaning within those parallel universes in the corporate spend. So yeah, for me, that's and I would argue in the specific domain that I work in, supplier management, where Sirion Labs is today, 50% of what is done manually today will be automated by our solution day one, and our goal is to get to somewhere between 80 and 90% in about 18 months.
Yeah, before we go, you Ross, Jamie, I see had a comment on this thread.
Yeah, I was just going to comment on the whole advice giving thing and whether machines can give advice. I mean, again, this is not a technology problem, this is a regulatory problem. There's any number of experts, people who build expert system tools who can teach them how to give advice. And I mean, our product does simple decision tree logic, so you can achieve a lot with that, but there are other tools that do fancy things like backwards chaining, inferencing, and all this other garbage that I don't quite understand. But that, you know, there are very sophisticated expert system tools out there already. The reason they can't be deployed probably more aggressively is because it's giving advice, and that's something lawyers can do and no one else can do.
Okay. Now we're going to shift gears a little bit because we're going to hear about this project that Nevada has undertaken. And I should give a little bit of a disclaimer in that I am one of the originators of some of the software at being used in this context. And so I'm a natural fan of this project, as you might imagine. But Ross, do you want to take it away? You want me to work on finding the...
Sure.
Okay.
Thank you. I'm obviously a little bit of an odd duck on this panelist, coming from the public sector, where we're always about 20 years behind adopting this very advanced discussion. Probably more appropriately fit into the 1993 debate about the future of technology. So my role may be just to try to dumb down the practice of these ideas. When I first came into office in 2007, I oversaw the Commercial Recordings Division in Nevada, and Nevada is second per capita in the number of business entities we have on file, behind only Delaware. So we are known as a very favorable business jurisdiction, and you know, I think what it means is that when viewed in the eyes of the nation's business public, Nevada is the second best place in the country to incorporate to do business. And we got there for a couple of reasons. One, we stole Delaware's statutory scheme, lock, stock, and barrel across the board. And adopted very favorable business statutes. But second, we were known as a very favorable filing jurisdiction in terms of the ease of transaction. We invested heavily in our processing system so that instead of having to wait weeks to form your company, you were able to do it relatively quickly. And we've continued to invest in that. So when I came into office in 2007, I came forward with not necessarily a novel idea, but an initiative that I wanted to tackle, and it really hinged on the fact that, you know, many of the biggest companies in this country are started from the most humble origins. You know, somebody has an idea in a garage. Some of those ideas not so far from here, literally, that's where these companies came from. And they want to translate that idea into a business. But the process of establishing a business and navigating the absolutely mystifying process of establishing a business in this country is absolutely mystifying. And so what can we do to make that process simpler? Nevada's not unlike any other jurisdiction where if you want to set up a business, you first have to go to the Secretary of State's office, set up your LLC, oftentimes obtain your business license. You got to go to the Department of Taxation, register with them. You've got to file industrial insurance forms. And oftentimes this process is paper-based. You're given the same information to these different governmental agencies repeatedly, all the way down to the counties and the locals. You know, you're given 45 forms, different processing platforms, etc. There's no reason for it. Obviously, technology exists to be able to simplify this. And so the idea was we should have a one-stop shop. And the Secretary of State's office is the natural hub to be able to do that. And so we began this initiative of trying to identify, when you set up your LLC, what information are we collecting? Can we collect this information one time? To identify the common business registration data that is used repeatedly throughout every agency, and then figure out, you know, what additional supplemental information is required. And at the end of the day, should you be able to just check out and process and pay for all of those licenses through one single shopping cart. And next year, if you want to renew any of those licenses, you just log onto the website with your ID and indicate whether or not any of the basic identifiers have changed, and you renew those licenses. We made the case for this politically, but by demonstrating that there was a tremendous amount of uncaptured revenue that was being left on the table. And so we were able to build this system. And it's in existence. You can see the slide here, silverflume.nv.gov, where you can process not only all of your online filings with my office, LLCs and the like, where over 70% of all the transactions we now have are done entirely online, but also get your licenses with the Department of Taxation, down to industrial insurance certificates. We've got about 15 partnered agencies at this point, and working to expand this down to the locals. But when I was developing this initiative, I was sitting on a Sunday reading a book, stumbled on a chapter written by Professor Goodenough, who was, yeah, there it is. And he was talking about this idea about the digital formation process and the fact that this is the direction that we needed to head. But he had two additional novel concepts that I hadn't really thought about before. One was that, you know, most businesses, or many businesses that are very small in their origins, don't have the means to establish a legal contract between the parties initially, and the basic operating agreement between the parties could be done entirely in a digital realm. The second is that once you have licensed yourself, there's no reason why the company couldn't legally be entirely governed in the digital realm. And so when I got done reading that chapter, I called him the next day, and the cool thing about being Secretary of State is that occasionally when they hear the title, people pick up the phone and tend to call you back. And so he did. And I said, you know, can you tell me a little bit more about this? I mean, have you advanced this? And he, in fact, had some model language that he had put through the Vermont legislature. And so I borrowed that, put it into place. And I said, about this digital operating agreement, you know, what more do you have to tell me about this? He says, well, it's in practice. You know, the Berkman Center actually developed this software program. We wrote it, and you know, it's sitting on the shelf as kind of an academic exercise. I said, well, we want it. You know, can we roll this in to our Silver Flume initiative? And so we did. And so now in Nevada, you can license your company entirely in a digital realm. You can create a digital operating agreement, which will walk you through the basic contractual provisions. We acknowledge that it's not sophisticated enough to handle complex transactions, but for very simple companies, it works, and it works really well, and people are using it today. And then we changed the statutes so that you can run that company, if you want to, entirely in the digital realm. You can have your meetings via Skype, because the statute allows you to have sequential or simultaneous communications. You can propose business decisions through this software program that Professor Goodenough developed, and agree to those terms entirely on this software platform. And so we're working to expand this. But I think it's promising. But I think what I've learned at the end of the day is that this is not a technological problem. What I probably should have realized in 2007 is that I should have looked around and realized that no other state in the country was able to really do this, to develop a one-stop shop. This is more of a political problem, kind of hinging off of what Jamie has said. The challenge is breaking down those silos, those fiefdoms, and really getting everybody to collaborate, because the technology is clearly there to be able to do this.
Thank you. As you can see, I may be a little reluctant to ask you some critical questions in this circumstance, but you say it's not a technological problem, it's a political problem. I would turn it around and say it's a technological and political problem, that indeed this is one of those places where we need to have a partnership. It is not solvable, as I think we heard in the earlier pieces. You know, people with clever technology run up against rules. People who have set rules in a particular way run up against technology. How were you able to bridge that gap in your own department? Was that something that was easy, or was it hard?
No, it's been, I'd say, incredibly hard. When I looked at this task in 2007, I thought it was just a case of the public sector being very slow to embrace the private sector technology. In fact, it is a more difficult challenge politically to try to break down those silos. You're dealing with licensing agencies throughout the state that have developed their own fiefdoms, their own process. They want to own their data, and they are reluctant to change. And so you've got to demonstrate this in a way that the technology will work for them. That we can make it adaptable to your system. It won't entirely change your process. We're not going to take your money. Here's how the payment platform functions. And until they really see it in practice, they've been resistant to it. And so that's been some of the challenge and why it's been slow moving.
Kingsley, you had a comment.
I want to test this concept that I think is the underlying assumption here. The technology is just an enabler. It's just going to sit in the back office. Let's see how far we can push it. Let's just take it in the contract domain. Let's take the skill level of, say, a junior associate. The question is, what should be in an employment agreement? Who would perform better today in a little test of writing down what I expect to see in an employment agreement, computer versus a young associate? Again, I think I do just fine. The second level question, what should be in this employment agreement? Actually thinking about the contractual terms for a particular engagement. Now, we're not there yet. But without a doubt, looking across not just the handful of contracts that any given senior associate might have looked at, we can look at hundreds of thousands. And just as Watson is getting trained in oncology, we can train a machine in employment. And it will likely predict a better answer than even a partner. Let's take it to the third level. What are the aspects of this agreement that are going to impact the operational and risk factors of the employer in which this contract actually works? I'm not sure I've necessarily thought through all the pieces of that, but if we define XML structures that can relate to other operational databases inside the organization, I think we can go a long way to that question too. But the first two, the one I'm working on, I think the technology can do a lot of what attorneys are doing today, including senior partners.
I'm going to be give a little capstone of my own here before we open it up to questions, which we'll do in just a moment. To take on a piece, another piece of the future, which is as we talk about operationalization, one of the things that was very exciting to work with Nevada on, and on this software project that we did, was that our goal was not just to use software to describe and create better agreements. Our goal actually was to use software to be the agreement. That essentially, if you think of a contract or a regulation or law for that matter as a set of if-then clauses in a structured way with certain kinds of consequences, a branching statement of various kinds, you can then view that as something you can put into a software original. I want to shout out a moment to my colleague from Vermont, Jeannie Ikes, who's here, who helped me understand that essentially a contract is a workflow design. And that by if you think of it in that way, there's no reason why we should use all of this software to create word-based embodiments of the workflow, when we can have code-based embodiments of the workflow. And indeed that you can embed into the code-based description all of the kind of branching statements that you would put into a word-based one, in fact with much greater precision, and the next step being that once you've made it into software in the way that we've managed in Nevada to create a software contract, you can then put all of the functionality into the software as well, or at least much of the functionality that you want. So the contract not only embodies its information, it embodies its own execution. And indeed, that's a kind of a next step that I think we can view going on here. Because when you do that, when you embed the execution as well as the description in the software as a conflated unit like that, now we get to the point where the contract and law becomes itself computable. Because now you can compute within this world a bunch of the interpretation of consequences and even delivery systems. So at least that's as I think about it, where I think one of the pieces of where we're heading with this, and one of the reasons why the example of the Nevada silver flume is to me exciting, because it is an example of having put those elements into it so that the software is the agreement. We're not using it as a proxy for a word-based thing.
Agreed, but all of what you described is low-tech. Try to get a genuine technology engineer interested in any part of what you described, not going to be interested.
If you can monetize it sufficiently, I suspect we could get them interested.
And why do I make that remark? So the first 5 years at UnitedLex, I worked with a whole generation of very bright engineers, primarily from the IITs in India, and tried to get them interested in the limited legal problems that we were tackling. The problem was the mandate of my previous company was very narrowly rooted within the law, in the disciplines of IP, contract management, and litigation support. And the problems there are fairly small and routinized. What you described, contract authoring, is a really rudimentary workflow. Contract authoring tools, more grandiosely referred to as contract lifecycle management systems, and there are 4 or 5 big companies in the world today that do those, are not high-tech at the end of the day, because these workflow steps are relatively simple. Then you get to the question of variation, which is what Kingsley is tackling. Template formation, variations that exist. Okay, reasonably more complex, but not on the technology side, on the data side. Assembling the data and matching the right variants against each other. Where it gets really interesting, and where I think technologically also it becomes more challenging, is when you situate the contract in the world of operations, and you start collating legal data or measuring legal data against performance data. I think that's the point Kingsley was making a little earlier, and that's a much bigger universe. That's potentially where the B becomes capitalized in the big data as well. So anyway.
See, I don't see it so much as being embedded in a piece of software as just being, you need the agreement to be represented, right? You need the terms of the agreement to be clearly represented somehow. And one of the key enabling technologies, in my opinion, has been around now for 15 years. That's XML. So you have this markup language that's designed for machine-friendly processing. So you have a way of marking up a document that can represent data and language quite well, in fact, very well. So you have this, standard for creating standards, which is what XML is, and if all contracts could be represented as XML with particular standards of, the semantic markup, if you bring if the semantic web meets the world of contracts, then you could represent all contracts in a machine-friendly format. And that would dramatically change, everything, because they can all be linked the way that, because you have an amendment, the amendment refers to the original contract, those things can be linked. And I see the biggest barrier to all of this is being our good friend Microsoft Word. Because what Word does, and most lawyers are addicted to Word, is it takes, or you might say the biggest barrier to all this is client-side software. So Word takes the contract onto the client side where anyone can hack away and make a complete mess of it, and where it's not managed as an XML document. If this thing could stay on the server and be edited, negotiated without leaving the server, then you can store the whole contract as an XML document. You can have it richly tagged, richly structured, and you can get that right through to execution, and then you don't have to worry about all this scanning and natural language processing and all these other problems. You have a document that started life in a machine-friendly format, is richly, richly marked up, and lives its life in that machine-friendly format. And if that transpires, then all contracts are machine-readable, all contracts are sort of open to a new world of analytics. Visibility for regulators is massively improved. It just changes everything.
Kingsley.
Just a quick comment. We talked a lot about how we're going to do this through the logic-based if-else-then or semantic. I don't believe either actually are going to be the way that it's going to actually happen. The breakthroughs are coming. Sorry, the methodology of doing this could be done through logic, if-else-then statements. It could be done through some kind of semantic web. The breakthroughs are actually happening with statistical analysis, the way Google is doing Translate, the way Watson is being trained. We're doing the same things with the statistical analysis of these contracts. It knows nothing of the meaning of it. It doesn't matter whether the contract is written in English or French. It can still find these things, and we can still, from this database, ask really meaningful questions, like, what kind of terms can I put into this contract? What will satisfy the market needs? And again, the machine can come back with a really strong answer without knowing one meaning of the word that was in there.
We have a question. Would you introduce yourself before you ask it?
Sure. Franny Lee. I worked with CodeX for a number of years and have recently spun out with a homegrown research project that deals with copyright technology. My question deals with, I think what you guys are talking about is fascinating in terms of development of the technology, but equally as challenging is the adoption of that technology once you develop it. And that's, Ross Miller, your comments on breaking down the silos and breaking down the fiefdoms really rings true. My question, and I want to hear from all of the panel, but particularly from Mr. Miller here, what did you have to do to break down those silos? And do you think that being in the public sector and having governmental influence helped you? Was it an advantage or a disadvantage? And then kind of to hear the combination of the public sector, private sector comments on this.
Thank you.
It's a good question, and I'm continually working to try to break down those silos. I mean, just last week, I got hailed before a local government entity who sent me a nasty letter because they learned about my initiative and the efforts to move forward and wanted me to come and explain myself. And so that's what you deal with. It's more challenging, I would argue, in the public sector because Now I've got these egos and personalities of the elected officials who oversee this licensing process, and I've got to manage that. We've tried to demonstrate the case for this initiative by demonstrating the efficiency, that these processes are completely redundant. There's no reason for it. Technology exists. We should move this direction, which I think people are responsive to. But also, the fiscal case that this licensing agency may know you as Kayak Inc., but over here, you're doing business as a DBA. If those, different databases aren't mapped together, you're losing out on a tremendous amount of revenue that's going completely uncaptured. Once you tie all of these in and you have a unique identifier to be able to know this business entity throughout the state, through all these licensing agencies, now you've realized a tremendous amount of revenue. So it's been a work in progress, but those are some of the challenges we deal with.
Great, thank you. Yes.
Andrew Fong, I'm an attorney. For the entrepreneurs on the panel, I was wondering, to what extent, when you're building your company, does it make sense to focus on problems across processing contracts in general versus focusing on particular verticals like employment contracts, like tax? I mean, obviously, you want the technology to address everything in general, but from a business perspective, does it make sense to focus on one thing first?
Yeah, I mean, I'll take a shot at that. I mean, it's definitely, from my perspective, and I didn't invent this theory. This is crossing the chasm 101. It's better to focus on particular industries. I think particularly if you're targeting enterprises, But you want to be very focused if you're a startup, right? If you're not very focused, you're probably going to fail. For example, in our case, we were fairly general. We started life targeting law firms. We thought, look, every law firm is going to want to automate their documents. And, of course, every law firm was addicted to the billable hour, and if you sell someone addicted to billable hours a productivity tool, they look at you like you're crazy. So we quickly adapted to realize that the corporations were the ones who would embrace this sort of technology, and have kind of de facto fallen into a focus in financial services. So we have lots of banks, lots of insurance companies who are automating things. So I think if you have an industry focus, it's just going to make you can be more focused about product features, and you can understand the industry better, and that just helps you sell better.
I mean, we see it very simply. Stage one was consulting. We go work with the law firms and the corporation, and we essentially adapt the software to do whatever they want. Stage two, move it to software licensing and enable them to do it themselves. But the third stage is to move into the content space and establish the standards. And we will start with the broadest one possible, the one that every single corporation has, which is employment-centric.
Thank you. Yes.
Hi, I'm still Ron Dolan. I want to raise the issue of automation and the way that we look at quality. And so I think that it's often the case that when we start bringing in automation in law, we see an improvement in quality as well as efficiency. But without measuring, I get concerned. And I think what we see is sometimes when we try to measure the quality of an automated system, we want to compare it with humans, and we find out that the human system actually is worse. But that forces metrics, and that's really helpful. My concern is when we start moving into the public sector and we start imposing automation because of a lack of resources, as we see starting to happen in small claims courts, et cetera, with online dispute resolution, et cetera. If we don't have metrics, the question is how much justice is efficiency worth? And I'm concerned that, with Kingsley's system, it's statistical and there's somebody who's really knowledgeable who's picking between a bunch of choices, and I think that that is really efficiency without a loss of quality. You're just getting somebody to the point faster. I just want to raise the issue of how we make measurements on these things. I don't necessarily assume that a decision tree gives you the best solution every time, and there's trade-offs that we're making that concern me. And I just want the metrics to be in place so that we would know when do we need to bring in a human to look at this, and or when is it okay to impose this. So, okay.
Well, step one, we need a measure. We need something to measure these documents against. And that's one of the things that I see on a daily basis, that there hasn't been a metric against which to examine these documents. And I see a range from things that obviously someone spent a huge amount of time thinking it through, to material that is shocking in its quality. I mean, we see contracts that are missing key provisions, contracts that have the same term, literally 2 clauses apart, saying completely different things. So stage 1 is create the metric. Now, is that metric a high standard? No, just as Oliver pointed out in one of his earlier questions, the metric is itself the baseline of what we see today. It is the best of what we see out there. And we can, of course, not only apply mathematics to it, we can apply editorial standards too. So I think we set a baseline which is today's best practice, and we seek to raise the bar and measure people against it.
In engineering, best practice usually is it's often that you write your test first before you even start on the part of the code. And what I see with a lot of the legal systems is we don't necessarily look at getting an evaluation system in place first so that we know that the system is working better. Like I say, I do think it often does work better, but we need to measure.
The real problem with lawyers is they're also opinionated. They can never agree on what is best practice. I mean, you just need to look at law firms trying to standardize their model, form documents. Like, it's almost impossible. They all think they're right, and they can't all be right. So you have an extremely opinionated, argumentative community, which is part of the problem in developing benchmarks.
And indeed, imagine a system that's had no quality control checks for hundreds of years. And you have what you have
It's
today.
certainly better to pick between 3 preferred choices than to just, at random, put a bunch of words together, right? So, okay.
Thank you. Yes.
So I note that 3 of the panelists have accents that suggest that you were born outside of the United States in a jurisdiction where you have more flexible regulatory environment, and you have a better chance than me at picking up someone at a bar as a result. And I also noticed that Oliver's software sat on the shelf for years until Ross finally picked it up. And I got to say, the first thing I thought for you, sir, was I hope you don't get sued for UPL, unauthorized practice of law. The semantic web, which has been brought up a couple times, isn't as polite about national barriers as we tend to think of, the polity basis of U.S. law. So my question to you guys is, what do you think? Is the porous nature that technology enables of a regulatory environment going to mean that forget about what the U.S. law has to say in terms of regulatory restrictions? Is the multinational nature of the web going to enable extra-jurisdictional opportunities to practice law?
Actually, I think it's a tremendous export possibility from the US. This is really what we're talking about. The contract standards we're talking about are really the global language of business. There are many emerging countries that could benefit from the Anglo-American system.
And whether it's an Anglo-American system or a more continental system, one of the things that sits out there is that institutional quality is generally linkable to societal benefit in all kinds of dimensions, whether it's economic prosperity, how we live our lives, a whole set of things. And one of the things that's interesting about once you start to turn institutions into digitally instantiated objects of various kinds is that they become even more exportable. Someone with a cell phone in a part of the world that doesn't have terribly good contracting could, in fact, access contracting, whether it's through a LegalZoom or the state of Nevada. One of the goals, actually, in doing this software was to enable it to be so virtual that someone wanting to set up a company from Tashkent to Brazil to wherever could in fact simply go online, find a jurisdiction, boom, have a company. That in a sense, it's if you've got cloud computing, you can have cloud law, you can have cloud institutions, you can pull them down from out there and get the benefit of them. So at least I think that this notion of being able to export institutions is a good one. I would mention, by the way, I don't mean to fully contradict Ross, but actually it was only on the shelf for a little while. and I will mention, and I'm sorry to do this to you, that one of the folks that I pitched with it, you know who I pitched with it was LegalZoom.
Yes, I do know.
There we are.
No, that's very true.
And Nevada took it up.
I think you're correct to call me out on that, but I will also take that to sort of further the point, which is you do quite a bit of work with your LLC product. And I know we were just told by a counsel, not a state official, but by counsel, that in some United States, spell check on a contract could be considered the unauthorized practice of law. So my question to you is really like, okay, if you could avail yourself of another jurisdiction, is the U.S. going to be left behind?
Well, it's an interesting point. It goes back to some of this thing. There actually partly, but there may be more nimbleness in the public sector than the private around some of these barriers that you may see. I mean, as Ross is saying, this is all completely authorized by state statute, and therefore is what it is. Last question. I mean, we're going to finish.
This is obviously part of the debate. When we brought this statute forward, we did get some pushback from the legal community. And you know, it would focus on a couple of areas generally, which was that one, government shouldn't be in the business of doing this. You know, it's really replacing the legal function, and this contract in some ways may be worse than having nothing because it is so simple in its language. And our point in return was, we say specifically all through this legal agreement that this should not replace, you know, consulting with an attorney, and we advise you to do that. But, you know, if you're not going to have a contract, this may, you know, be a replacement. And the second pushback we got was, well, you know, if this is really just a stock contract, you can find that in a law library. So why do you need to be offering this? And the point is, obviously, that, you know, two parties who perhaps have never met, that may be in completely different jurisdictions, you know, are able to collaborate and form this contract entirely through the software platform. So it's a valuable service.
I really think it sounds like a great idea. I'm very impressed by this. You know, I think it's fantastic. But I think the pushback that you're getting from the legal community is in some sense what I'm talking about. You know, it's kind of amazing to me that the Secretary of State of Nevada is being challenged on whether or not it's a good idea to help people have access to law. You know, that's, and other countries are saying no. The UK is saying no. New South Wales is saying no. South Korea sounds like it might say no soon. So I just, you know, think maybe the US is going to get left behind here.
Last question.
So, in 2 weeks, I go to the Vatican to talk about ethical banking. And so listening to this, and they've had an issue. Listening to this, I wonder if law is just the first hurdle and whether you can use this same semantic parsing on other domains of standardization. In this case, you have Torah, New Testament, Quran, you name it. You've got a whole bunch of legal contracts, albeit with another counterparty. Ultimately, there are outcome determinative, you know, uses of operationalizing this set of contract principles for good or bad impact at community and personal level. So, you know, I'm being a little facetious, but you can imagine deconstructing engineering or deconstructing medicine more using this process than some of the whoever, WebMD formats in which it's occurring. So, you know, while the battle may be pitched by the large law firms, and we've heard a lot of that already, you have other professionals who are going to be impacted by the approach that this technology is taking. And you could, in effect, be your own rabbi, you know, priest, faith leader, and it would work. So I wonder if you've been approached to use this technology by other domains.
I'm not sure I'm going to go all the way you have into the world of theology, but I do think that it's fair to say that we are not facing problems that don't have their analogs in other domains as well. Jamie, do you want to have a last word?
I was just going to make a bad joke. I mean, if you're contracting with a divine entity, it's a bit like contracting with a sovereign. You want to make sure you've got a waiver of divine immunity.
on that bad joke. Thank you very much, panel. I appreciate your participation and wisdom.